happened with the Constitutional Convention, as it was called, there were two plans that were drafted. One was the Virginia plan, which gave a lot of power to the states, and the other plan was the New Jersey plan, which was questioning the power of the people, population. So eventually they got the two plans together, and it became known as the Great Compromise. And the Great Compromise is what eventually forms the Congress of the United States of America. Because in the original Articles of Confederation, all that they had was a Congress. They did not have an executive branch or a judicial branch. So the US Constitution will be born out of compromises, the New Jersey plan and the Virginia plan. So when we're looking at the US Constitution, it's a document which explains compromise. And so it is built on compromise. Now the US Constitution was drafted in 1787. The 13 colonies at that time were states. If you know your history, the states were created by the Northwest Ordinance. That's what provided for the colonies to become states. And they had to reach a certain population. With the Northwest Ordinance, it was 60,000. So whenever a state reached 60,000 in population, they could apply for statehood. The first state to draft and ratify the US Constitution was Delaware. So from 1787 to 1789, that it took the 13 states that much time for them to ratify and adopt the US Constitution. So by 1789, on March 4th, the US Constitution is ratified. And it becomes the law of the United States of America, but not officially. It was not until 1803 that the US Constitution was made law. And that happens because in 1800, you have to know a little bit about the case called Marbury versus Madison. That's a very important case in the history of the United States. It's one of the earliest cases. But in that case, Marbury versus Madison, what happened was there was an election in 1800. The president of the United States at that time was John Adams, who was our second US president. John Adams lost the election. Not by much, but he lost to Thomas Jefferson. John Adams was a Federalist. He believed in a centralized government. He believed in business. So he was a big supporter of business and a huge supporter of centralized government. That's why we had a Federalist. There was another party at the time. The other party was the Democratic Republican Party. And the leader of that party was Thomas Jefferson. And he supported agriculture, and he also supported the farmers. So farming and agriculture are the things that he supported, along with decentralization. He was not a believer in a strong central government, but he did believe in an efficient central government. So eventually, what happens, 2 days before John Adams left office, what he did, something very unusual. He appointed about 60 justices to the Supreme Court, to the judicial system, 2 days before he left office. A lot of these justices that he appointed, some of them did not receive their commissions. The person who was supposed to give them the commissions was John Marshall, his Secretary of State, who later on would become a Chief Justice of the Supreme Court under Thomas Jefferson. So the commissions were not delivered. So when Thomas Jefferson became president, he was ordered by the court, the Supreme Court, that's what we call a writ of mandamus or mandamus, to deliver the commissions. He refused. So Marbury, one of the gentlemen, one of the individuals who was supposed to be given a commission to serve in the judicial branch, sued. And the suit took place in 1803. So in Marbury versus Madison, what was concluded there at that time, the Chief Justice was John Marshall, and the Secretary of State at that time was James Madison, who would eventually become our 4th US president. So that's why it's called Marbury versus Madison. And in that case, what you see is John Marshall ruled in what we call judicial review. Judicial review says simply that it is the purpose of the Supreme Court to say what the law is. So whenever a law is passed by Congress, it is the responsibility of the Supreme Court to interpret the law. So that's where the US Constitution is born. The idea of a judicial branch supporting and protecting the civil rights of individuals is born with judicial review. And from that point onward, other items went into the judicial branch. The purpose of the judicial branch originally was to protect individual liberties. So that's why we see things like writs mandamus. That's why you see things like no bills of attainder, which simply means you cannot arrest a person without a jury trial. And in the same breath, you have what is called habeas corpus, which means that if a person is arrested, he must be taken before a judge for sentencing. So all of these things, if you go back into the colonial times, into the history of England, a lot of times the king in England was a despot. That means it had absolute power. So when any enemy of the king was threatening his rule, he could have him arrested and imprisoned without a trial. So when the colonies declared their independence in 1776, on July 4th, with the Declaration of Independence, the battles were still waging on. The American Revolution ended in 1781 with the Battle of Yorktown, but officially it doesn't really end until 1783. So by that time, we already have a legitimate government in the United States of America, one law, the US Constitution, and people were still saying that it had to be amended or changed to give people more individual rights. So in 1791, the Bill of Rights were ratified. And all of you should know the Bill of Rights. There's 10 of them. In the US Constitution, there are actually 27 amendments. But the first 10 are called the Bill of Rights because they promote certain freedoms, individual freedoms. And of course, if you look at the First Amendment, it says freedom of religion, freedom of speech, freedom of the press, freedom of assembly, freedom of petition. Those are rights that are inherently individual. Freedom of religion, there are limits to the rights though, because freedom of religion, if you look at the US Constitution, it says, we the people. And if you look at the history before the American Revolution, there was a period known as the Enlightenment. And in the Enlightenment, they taught things like we have certain natural rights. One of them is life. The other one is liberty. And the other one is we have the right to own property. Well, in the American government, they took those ideas, but they changed property. They said life, liberty, and the pursuit of happiness. So in the US government, from the Declaration of Independence and the US Constitution, the idea is very simple. We, the people, we have the right to life, liberty, and the pursuit of happiness. So if these are natural, then we have the right to life. No one has the right to take our life. We have the right to liberty, and we have the right to enjoy and pursue happiness. So when we're looking at the First Amendment, we're looking at religion. Freedom of religion really is limited, because if a religion teaches that it's okay for you to hurt someone else, then you are violating freedom, the freedoms that we have historically of we the people. We have the right to life, liberty, and the pursuit of happiness. So religion is a limited right, along with freedom of speech. For example, I have had students who always say, well, I have the freedom of speech. I can say anything to you, Mr. Rosas, that I want to. And I would say, well, yes, but you see, I have certain protections by the US Constitution. I have the freedom to be free from that kind of treatment. You might have the right to say it, but it doesn't make it correct. Because another Enlightenment thinker said something like this. He says, his name was Voltaire. He was from France. And he lived a little bit before the American Revolution. And a lot of people didn't like him very much, but he did say something that's very, very profound. He said, I may not agree with a word you say, but I will defend to the death your right to say it. And so that means simply that you have the right to speak whatever you want to say, and someone else has the right to not have to agree with it. So we have freedom of religion, freedom of speech, we have freedom of the press, newspapers, but we also have the freedom to assemble, to peaceably assemble. And I always tell my students, peaceably assembling means that you can protest peacefully. But once the protests become violent, then you can be arrested. And of course, petition, a lot of people don't really understand what petition is, but petition simply, in layman's terms, petition means that you can complain. You can complain. Amendment number 2 deals with the right to bear arms. It says the right to keep and bear arms. So in other words, amendment number 2 says that you can keep arms or weapons in your home or in your person. But what I always tell my students is, you can keep and bear arms. It doesn't tell you that you can use them. It does not say that. Now, amendment number 3 deals with what we call the quartering of soldiers, and we don't even use that one anymore. Amendment 3 is obsolete, because back before, in colonial times, British soldiers had to have a place to live. Remember, the original 13 colonies were established by British citizens. There were English people that came here. And there were many reasons why the colonies were established. Some were established for religious purposes, others were established mainly for business, to make a profit. So English people from Great Britain or England, today we call it the United Kingdom, came over here to the 13 colonies to start colonies and make money. Some were, like I said, were established for religious purposes. Maryland, for one, was established as a Catholic debt colony. So that would be an example of religion in the colonies. So when we're talking about amendment number 3, since there were British soldiers here, because if you're familiar with before the American Revolution, there were soldiers in the colonies because there had been a war. It's called the 7 Years' War in Europe. But here in the colonies, it was called the French and Indian War. And it lasted from 1754 to 1763. This is a few years before the American Revolution began in 1775. So the soldiers were there, and there was no place for them to stay, so the British government passed what is called the Quartering Act, which forced the British soldiers, or better yet, forced the American colonists to provide housing for the British soldiers. And the English colonies considered that a invasion of their privacy. So when they came up with the Bill of Rights, that's why they developed amendment number 3. But today it's obsolete, we don't have to worry about that. Amendment number 4 deals with search and seizure. It says something like, you have the right to be free from unreasonable searches and seizures. Okay, the key term I always tell my students about that is unreasonable. So, in other words, if you are stopped by a policeman and you're driving your car and you're speeding, do you think he has a reason to stop you and search your car? Or if you're just sitting in a park bench and the police officer comes over and says, I need to search your bag, is that unreasonable or reasonable? So that's the key. And usually police officers have to have what is called probable cause to search your vehicle or search your person or your effects, or even go into a house and search to see what's in your home. Of course, they would have to have a warrant for that. So it's all based on the idea that there has to be a probable cause for it. So as long as the search is considered to be reasonable, then that is within the Constitution, the protections in the U.S. Constitution. Here's one that I tell my students every once in a while. If you were to go to Disneyland, the first thing they're going to do is they're going to say, let me see what's in your bag. And you're going to go, wait a minute, you're not going to look into my bag, because that's an invasion of privacy. And they'll say, no, it isn't, you see, because you're entering into a public place. So for the protection of all of the people here, what if you have something, a weapon or something in there, we have to protect their liberties, we have to protect their life. So therefore, your right to be free from search and seizure is limited in public. So they'll search your bag, and that's just the way it is, because you see, even though you have certain rights, so do the other people. And that's why we have search and seizure. As long as it's reasonable, it's within the Constitution. If not, then that's why we have trials. Amendment number 5 specifically deals with due process. Due process is you have a say. I tell my students, if you are in school and the principal calls you to the office and the principal says, you're expelled, leave and you cannot come back, that's a violation of their amendment number 5, because they have a due process, which simply means they have the right to give their story, to give their side. And due process always has to do with a hearing. So Amendment 5 is the due process right. Amendment number 6 has to do with the right to a speedy and public trial. Nowadays, I have a feeling that trials sometimes take longer than they're supposed to, because there's just so much there on the docket. But what is a speedy and public trial? And by your peers. So according to Amendment number 6, you should be tried by your peers. And here in the United States, you are innocent until proven guilty. Amendment number 7 simply deals with money. You can sue for more than $25, but that also is obsolete today, because I don't believe any judge out there is going to take a case for $25. It just doesn't work out that way. When we're looking at cruel and unusual punishment, that's Amendment number 8. So Amendment number 8 deals with cruel and unusual punishment or excessive bail. So what exactly is cruel and unusual punishment? Throughout history, depending on the cultures, they define what that is. So cruel and unusual punishment 300 years ago was something today would be something very grotesque. But to them it was normal to chop off a hand or a foot or something like that. But today those things are not ordinarily done. So that's what we mean by cruel and unusual punishment or excessive bail. You might argue, well, what is excessive bail? If you're caught speeding, the traffic ticket is $200, or you're put in jail and the bail is $1 million. I mean, that's excessive. To some people, that might not be. Amendment number 9 simply says that we have other rights. So if you look at Amendment number 9, there's so many rights in the U.S. that we have that are not mentioned. So if they're not mentioned, we have the right to privacy, but you won't find the right to privacy in the U.S. Constitution anywhere. So the founding fathers, they knew that the document, the U.S. Constitution, would be limited somewhat in scope in terms of rights. So that's why they developed Amendment number 9. You have other rights besides all of these that are listed there. You have the right to privacy, you have other kinds of rights. You have the right to be free from someone talking to you in a manner which would be disrespectful, libel, slander, things like that would be probably part of Amendment number 9.